What happens when authorities ignore judicial inquiries and substitute them with executive ones? 262 custodial death cases in Jharkhand remained uninvestigated by judicial magistrates, sparking a critical inquiry. 62 custodial death cases remained uninvestigated by judicial magistrates in Jharkhand. Executive magistrates conducted inquiries in these cases instead of judicial magistrates. The state disclosed that 427 custodial deaths were reported between 2018 and the relevant period. When the executive ignores the judicial inquiry mandated by Parliament and substitutes it with its own administrative process, it renders that procedure a mere farce, stripping the deceased and their kin of their fundamental rights. The Jharkhand High Court has ordered an inquiry into the failure of authorities in the state to conduct judicial inquiries in at least 262 custodial death cases. The court observed that substituting judicial inquiries with executive ones amounts to administrative lawlessness and reflects systemic disregard for statutory and constitutional safeguards. The public interest litigation was instituted on the basis of information disclosed by the Department of Home, Prison and Disaster Management, Government of Jharkhand, in response to a starred question before the State Legislative Assembly concerning custodial deaths between 2019 and 2021. The petitioner alleged that despite the mandatory statutory requirement under Section 176(1)(a) CRPC, the state authorities had routinely deputed executive magistrates to conduct inquiries into custodial deaths instead of judicial magistrates. During the proceedings, the state filed a supplementary counter-affidavit disclosing statistical data relating to custodial deaths from 2018 onwards. Affidavit: 427 custodial deaths were reported during the relevant period. While inquiries were claimed to have been conducted in all cases, the affidavit disclosed that 262 inquiries were conducted by executive magistrates and only 225 by judicial magistrates. The court noted that the figures furnished by the state were mathematically irreconcilable, as the total number of inquiries disclosed exceeded the total number of custodial deaths. The bench directed the principal district judge of the concerned district and the principal secretary, Department of Home, Prison Disaster Management to inquire into the failure and submit a compliance report within 6 months. Was this verdict fair, or did the judge go too far? Tell us in the comments yes or no.
Here's what this means for you. If you are a victim of custodial violence or death in Jharkhand, file a complaint with the principal district judge within 60 days to initiate an investigation. Save this video for future reference.
Follow Legal Output on Instagram and Legal Output Official on YouTube for daily legal updates.